to today's podcast. Our topic for today is, do countries need to change their laws to follow international law? This issue has generated much debate because while international law promotes cooperation and common standards among states, countries also have their own constitution, legal system, and national interests to protect. I am pleased to be your moderator today, HAFIZAH. To help us unpack this complex issue, I am delighted to welcome our two guest speakers for today, SYAKILLA and Gwen. Welcome to the session, both of you. We are excited to hear your insights. Without further ado, let's begin our discussion. To our first guest, SYAKILLA, many scholars argue that when countries voluntarily ratify treaties, they are expected to ensure that their domestic laws are consistent with those commitments. Personally, I think these arguments make sense because international agreements will have little value if states could simply ignore them. So, SYAKILLA, what do you think? Do you agree that countries have a legal obligation to change their domestic laws to comply with international law?
Okay, thank you for moderator, HAFIZAH. Yes, I do. Generally speaking, when a country voluntarily ratifies an international treaty, it accepts a certain legal obligation under international law. To fulfill this obligation effectively, countries may need to amend or introduce domestic regulations. This is because international agreements often require states to take concrete action within their own legal systems. For example, treaties concerning human rights, environmental protection, or international trade frequently require governments to adopt laws and policies that are consistent with their international commitments. However, the extent to which international law automatically becomes part of the domestic law depends on the legal system of each country. Some states require specific regulations before international rules can be enforced domestically, while others automatically incorporate international law into their national legal framework.
Thank you, SYAKILLA. From your explanation, it seems that states should make reasonable efforts to ensure that their domestic legal system are capable of implementing the international obligations. When looking at SYAKILLA's argument, would you align with her stance, or do you think countries can find alternative paths without necessarily modifying their national laws?
Well, yes, some countries amend their municipal law because they are legally bound by treaty obligations under the principle of pacta sunt servanda. For example, in the case of Alabama claims arbitration, the tribunal held that a state cannot rely on the absence of domestic legislation to avoid its international obligations. However, other countries may not amend their laws because they follow a modest approach where they rely on the doctrine of incorporation, just as I mentioned before, where international law automatically becomes part of the municipal law, therefore legislative amendment will not be necessary. So, in addition, national interest and constitutional structures also play an important role in determining whether a state chooses to incorporate international law into its domestic legal system.
Thank you, Gwen. SYAKILLA, do you agree that constitutional structures and national interests largely determine whether countries decide to amend their laws? Or do you think states should place greater emphasis on fulfilling their international obligations?
Yes, I agree that constitutional structures and national interests are important considerations. However, I would respectfully disagree if these factors are used too broadly to justify non-compliance. States voluntarily enter into treaties, and therefore they should take the necessary measures to fulfill those obligations. Otherwise, international law may lose its effectiveness and credibility.
I see. So while both of you recognize the importance of constitutional arrangements, Kila appears placed greater emphasis on preserving the effectiveness of international law. But even when states intend to comply, conflicts may still arise between domestic law and international law. So, moving on to the next question. Kila, in your opinion, what happens when domestic law and international law contradict each other? And how should such conflicts be resolved?
Okay, the answer depends on the legal system of the country concerned. In some states, international law enjoys a higher status than ordinary domestic regulations, meaning that international obligations prevail when conflicts occur. In other states, domestic law, particularly constitutional law, may take precedence. Such conflict can create legal uncertainty and may require courts to determine which law should apply. In some cases, governments may amend national regulations to ensure compliance with international obligations. If a state fails to resolve the conflict and breaches international law, it may face diplomatic pressure, reputational consequences, or legal proceedings before international courts and tribunals.
Thank you, Kila. Gwen, do you agree that governments should amend their domestic laws whenever conflicts arise? Or do you think domestic constitutional principles should sometimes take precedence?
Well, I would disagree to some extent. Although international obligations are important, constitutions represent the fundamental principles and the sovereignty of a state. So, therefore, in certain circumstances, constitutional principles may take precedence. States should strive to achieve a balance rather than automatically placing international law above domestic law.
That's an interesting observation. It seems that both of you recognize the importance of international law, but there is some disagreement regarding how far states should go in adapting their domestic legal systems, which brings us to our final, perhaps our most controversial questions. Gwen, what do you think about situations where international law conflicts with a country's national interests or constitution? Should countries be allowed to refuse to implement international law in such cases?
Generally, I would say no, they cannot. But again, there is no global authority that can force a country to comply with international law. Plus, in reality, some states may choose not to implement certain international obligations when they believe that it would threaten their security, economic interests, and so on. For example, in 2017, the United States withdrew from the Paris Climate Agreement. It was justified on the grounds that the agreement would negatively impact the country's industrial interests. The US argued that obligations impose an unfair burden on American business, so this demonstrates how states may prioritize national interests over complying with international commitment. Although remember that there is something called Hughes-Coggins, where international law imposes obligations regardless of the state's context.
Thank you, Gwen. Kila, do you agree with Gwen that national interests may sometimes justify non-compliance with international law?
By the way, I understand Gwen's concerns, but I would respectfully disagree. If states are allowed to invert national interests too freely, the stability and predictability of the international legal system would be undermined. International law depends heavily on trust and good faith. Therefore, states should not easily use national interests as an excuse to avoid their obligations. However, certain norms, particularly just cogent norms, are binding regardless of a state's consent and must always be respected.
Thank you, Kila and Gwen, for your valuable insights. Today's discussion has shown that the relationship between international law and domestic law is far from straightforward. To sum up, Kila's focus on the effectiveness of international law contrasts beautifully with Gwen's points on state sovereignty and constitutional boundaries. Balancing these national interests against global obligation is, without a doubt, one of the greatest challenges facing international law today. Thank you to both of our guests for sharing their valuable insight today. Also, a big thank you to our audience for tuning in. We look forward to seeing you in our next episode. Bye!